Hello, and welcome to my channel, The Entrepreneurial Mindset. My name is Jay Berman, and today's business essentials are Essential Business Law Concepts, Episode 3. And since today, this is Halloween, hence the background. The concepts in this video come from my book, The Manual of Essential Business Concepts, which is available on Amazon.com, either as a Kindle paperback or hard copy versions. You go to Amazon search bar, select books, type in my name, Jay Berman, scroll to my book to purchase, and by doing so, you support my channel and my work in business education. Thank you. So today I'm going to discuss contracts, which are enforceable by civil courts, such as small claims courts. Contracts you're probably very familiar with. If you are an independent contractor or a gig worker, loans such as mortgage, car loans, student loans, personal loans, those are all contracts. If you make any kind of purchases, particularly sizable purchases of goods and services, those usually involve contracts, and leases, either for commercial or rental property, would be considered examples of contracts. So a contract is something that is a document that is enforceable uh, of an offer to perform or not to perform a specific act in the present or in the future. There are two people in a contract. The first is the offerer. The offerer is the person who actually makes the offer. The offeree is the person who accepts the offer. And the offer can be a person, it can be a business, it can be a government. The offeree can also be a person, business, or government entity. Contracts are governed by civil law, which provides remedies if a party breaks or breaches the contract. Usually when there's a breach of contract, there's monetary damages, and then of course the contract is enforceable. But what does it mean to have a valid contract? So a contract has to contain an offer and acceptance of that offer. There is a legal term called consideration, which means something of legal value has to be exchanged for the offer. This exchange must be in clear, written language that describes the terms and conditions. So it is advisable that any contract between two people, a person and a business, two businesses, two entities, doesn't matter, the contract actually be in writing. You don't necessarily need a lawyer, but the contract is advisable, needs to be in writing, particularly if there's a breach of contract and you need to go to court, such as small claims courts. There needs to be contractual capacity. In other words, both parties must be competent to sign contracts. Incapacity includes age, so people under the age of 18 cannot sign contracts. If someone is considered mentally ill, if the contract was signed under duress, if someone was drugged, if someone was drunk, these would not be considered valid contracts under these conditions. Now, a contract must accomplish a goal within the law. So anything that involves any kind of illegality, anything that's illegal is not considered a contract. You have to have voluntary consent. Consent must be genuine from both parties. The contract is invalid if consent was derived from duress, blackmail, or coercion. Again, the contract should be in writing. It needs to contain the signatures of both parties for the contract to be valid. Now it's very common to have e-contracts. So the signatures are either digital or encrypted, and e-contracts are, again, perfectly legal. There needs to be a termination clause, so both parties, once they fulfill their obligations or their duties and responsibilities, and both parties are satisfied, then the contract is terminated. So what are the requirements of an offer? There has to be intention. So the offer intends to be bound by the offer that they're making. There needs to be terms and conditions. And again, those terms and conditions must be clearly stated and understood by the offeree. And there's to be a communication. So the offeree receives the offer via communication medium, such as a letter or an email. It can be a text. And the receipt of the offer is not acceptance of the offer. So just because an offeree receives an offer does not necessarily mean that it's accepted. The offeree has to literally say, yes, I accept your offer in some manner. And then there's the acceptance of an offer. The offer accepts the offer personally or through his or her legal representative or agent authorized by the offeree to accept the offer, usually somebody like a lawyer or an attorney. Communication of acceptance in the medium determined by the offerer, and then the communication of acceptance made before the offerer's deadline. So if an offeree accepts an offer after the deadline, it's not considered a contract, particularly if there is a specific deadline. And most good contracts, most good valid contracts would have some sort of deadline that the offeree has to meet. If the offeree accepts the offer after the deadline, then the offer is not accepted. And there also has to be something written to terminate the offer. Offer revokes the offer if the offeree accepts the offer. So, in other words, the offerer sends an offer to an offeree. The offeree hasn't accepted the offer. Then the offerer says, "Nope, I changed my mind. I don't want this offer." And you have to notify the offeree that you're withdrawing or revoking the offer. The offeree can reject the offer. That would terminate the offer. Or the offeree can offer a counteroffer, which rejects the original offer. And also the offeree fails to accept the offer by the specific deadline offered by the offerer. Other means of terminating an offer, if either the offerer or if offeree are incompetent, as I discussed earlier. The death of either the offerer or offeree would terminate the offer. The destruction of the subject matter relevant to the contract. So let's say, for example, you wanted to buy a house. God forbid that house burned down, which of course would be considered the relevant subject matter. The house burned down, then there is no contract because the house was destroyed by fire. The offerer not legally authorized to make the offer. The offeree is not legally authorized to accept the offer. And when the offer involves any illegal conduct, no offer is actually accepted. It's actually terminated. So that's what I have for today regarding contracts. If you have any questions or comments, use the comment section below. Subscribe to my channel for more educational content about entrepreneurship and business education. And I thank you for watching.